The third element needed for a crime is concurrence. What that means is the act and the intent have to happen at the same time. This is rarely an issue that comes up in court, but still you have to know that that's the third component. You have an act, you have the intent, they have to happen at the same time. If they don't, then there's no crime. Here's a couple examples. Mary intends to kill her husband. She's on her way to go buy a gun. As she's driving back home, her spouse just happens to be walking across the street, and he's not really paying attention. He steps off the curb in front of her. She swerves, but she hits him anyway. Can she be charged with murder? That was her plan all along, right? But the act and the intent didn't happen at the same time. She intended to shoot him, clearly, because she went out and bought a gun. The fact that she ran him over with the car, and in this example, she swerved. She was going to get out of the way, but ended up hitting him anyway. That's what we mean by concurrence. There is no concurrence here. The act and the intent were at the same time. Consider this. The accused accidentally injures a pedestrian while driving. Aware of the collision, the accused rushes from the car only to find out that the victim is a hated enemy. At this point, the accused joyfully proclaims his pleasure at having caused the injury. Is this a crime? Is this a crime of assault? No, because the intent and the act aren't happening at the same time. There's no concurrence here. So that's what concurrence means. Now, those are the three required elements in a crime, with those couple exceptions that I gave you. But 99% of crimes will have a voluntary act and some level of state of mind that has to be there. The other thing that is included, though, that can be included, it may not be included, but exists nonetheless, that you have to be aware of, is something called attendant circumstances. These are the specific or specified factors that must be present when the crime is committed. This is something that the prosecution has to prove beyond a reasonable doubt. It can include the crime's methodology, the location, the setting, victim's characteristics, and a whole bunch of other things, right? Here's an example. It is a crime to recklessly destroy a book with more than 1,000 pages. So our act, what's our act? Destroying a book. What's the intent or the state of mind? Recklessly. Are there any attendant circumstances here? Yes, 1,000 pages. The book has to have 1,000 pages. It works with, how about rape? Forcefully having sexual intercourse with another without their consent. So the crime would be, the rape would be the act. What's the intent? I didn't give you the intent. When there's no intent stated, it will be intentional. Any attendant circumstances? Consent. Without consent. The district attorney would have to prove it was done without consent. Okay? So attendant circumstances, watch for those as we talk about charges as we go forward. Let's see, do I have something? I think we are going to move on to this example. Actually, this is a nice example to go over all of our intents here and all our states of mind before we get into some other elements that might exist. So one fine October day, Napoleon, an avid hunter, goes hunting for deer. An animal scurries across the path, and Nappy, in a flash, shoots. He discovers that he has killed a rabbit, which is prohibited in the jurisdiction. Just at that moment, Odie, a friendly game warden, appears and arrests him. And Nappy is prosecuted for knowingly killing the rabbit. Do you think he's guilty or not guilty based on the definition of knowingly? Which basically he has to be aware of the probability of the occurrence or the result. In this case, I would say that he was not guilty. It's a little hard to establish knowingly here. An animal scurries across the path and he shoots. He thinks it's a deer, but he shoots. So I don't think we have knowingly here. How about the same facts, except the statute prohibits recklessly killing the rabbit? Do we get recklessly with our two required elements that we have to prove for recklessly, or the test for recklessly? No, I don't think we get over the hurdle of there's no other explanation, no other reason exists. There is another reason it exists. He's out there trying to shoot a deer. I don't think we get the number 2. So work through these on your own too, so you can see them. If we were in class, I would be having you do this. Statute prohibits negligently killing the rabbit. How about that one? That's more likely. What would a reasonable person do? Would they just aimlessly shoot at something scurrying across? If you can make the argument for recklessness, think about it. Think about negligently as well. But in this case, I think he would be guilty. He would fit that definition of negligently in this instance. Now, what if it was a child that was killed? Is Nappy guilty of any form of homicide? Purposely, knowingly, recklessly, or negligently killing a human being? I bet the prosecution will try and make an argument for recklessly because it is a child. But then they'll back it up with negligently. You can't be convicted of both. It's one or the other, but they could try them both. They could try both. So work through those if you're struggling with the mens rea, because it will be a big deal. It will be certainly on the quiz for the week. It'll also probably be on the final exam. But we are really going to look at both the acts and the intents. You're going to have to identify those in all of the charges that we're going to be working on this semester. So make sure you know how those states of mind work. So let's talk about this other element, or two elements. They go hand in hand. Assault. We're going to go back to this assault in the first degree. A person is guilty of assault in the first degree when with intent to cause serious physical injury to another, he causes such injury to such person. So we have to have this thing called cause. The defendant actually has to be the cause of the harm. What's the harm? The serious physical injury. If a crime requires a bad result, causation and harm are also elements of the crime. You have to show that the defendant caused that harm. Of course, there are incidences that occur when the defendant technically initiates the circumstances, like sets the ball in motion, that results in a harm. But it would be unjust to hold the defendant criminally responsible. So we should talk about some examples putting that in play. So Harry and Mary get into an argument about their child custody agreement. Henry shoves Mary. She staggers backwards, and she's struck by lightning and dies. Can Henry be charged with intentionally causing the death of another person? Probably not, right? Because he did shove her and she staggered backward and she was in the beam of where the lightning was coming down to strike that spot. But it wasn't Henry who caused her death, it was the lightning. So what we have to look at here is this two-part analysis when we're talking about cause. Was the defendant the actual cause of the harm. And you have to ask yourself, but for the defendant's act, the harm would have never occurred. So if Henry didn't push Mary where she was right at that moment in the line of where the lightning was going to strike, she wouldn't have been struck by lightning. So, yeah, Henry is the actual cause, but he's the legal cause. And you have to ask yourself, was defendant's conduct closely related to the harm it gives rise to? And I think that's where Henry is able to get out of Dodge. The question is, was it reasonably foreseeable? Was it reasonably foreseeable that Henry pushing Mary at that moment caused reasonably foreseeable that the lightning would strike? No. I hope you're shaking your head. No. When this part of the test is being determined, this legal cause, you have to look at it objectively. It's an objective test. You have to ask, would a reasonable person have foreseen or predicted that end result? Write that down, because whenever you see this, when you see, was this person the cause, ask yourself, would a reasonable person have foreseen or predicted the end result? And would we have predicted Mary being struck by lightning? No, we wouldn't have. But what if Henry's act, the shove, caused her to move? They're arguing, let's go back, they're arguing about the child custody agreement. They're standing in their living room. They have a huge entertainment center with a TV on it and books, lamp, knickknacks. Henry shoves Mary. Mary staggers back into the entertainment center. It falls and a portion collapses on her and the TV hits her on the head and she dies. So let's go look at the analysis here. Actual cause. But for Henry pushing Mary, she would not have staggered back and hit to the entertainment center. It wouldn't have fallen over and it wouldn't have hit her in the head. Is he the result of her injury? Yeah. Is he the legal cause? What's the objective standard? Would a reasonable, remember what it is? Would a reasonable person have foreseen or predicted the end result? Yeah, that's very foreseeable. If you get shoved into something, what if they were outside and he shoved her and she tripped off the curb into the street in the path of a car? Would that be reasonably foreseeable? Yes, it would. So that's how cause and the harm play into each other. So you have to ask, was the defendant the cause? But what happens when this intervening superseding cause happens? The lightning. That's what it's called, when something interrupts the chain of events that the defendant started, and that was the lightning. This is going to cut off the defendant's liability because that intervening superseding cause is much closer or more proximately related or resulting in the harm. Okay? What if, one more example. What if Henry, I'll have to come back to old Jennifer and Bob here, but let me give you Henry before I lose my thought on the intervening superseding cause. So Henry and Mary, again, Henry pulls a knife and chases Mary out of the house. Mary escapes Henry and hides in an abandoned shed. Half hour later, Wes, who's a homeless man, returns to the shed from panhandling. When he sees Mary, he kills her and steals her jewelry. So is Henry liable? Henry charged with murder? Was Henry the actual cause? But for Henry pulling a knife on her and chasing her out of the house and she having to hide there, yeah, he's the actual cause, but is he the legal cause? Would a reasonable person foresee that result happening? No. So Henry would get off. How about, now I'll go to this example in front of us. While driving along the highway with Tara in the passenger seat, Jennifer spotted Bob, her fiance, several car lengths ahead of her. She speeded up to wave at him. Bob, recognizing Jennifer in the car behind him, waited until she almost caught up to him and then sped away. Jennifer then increased her speed so she can catch up to Bob once more. Again, Bob thought it was funny. He was laughing. He waited until Jennifer almost caught up, and then he increased his speed even more. They played this cat and mouse game until Jennifer, who was well over the speed limit, lost control and hit a tree, and Tara died instantly. Can Jennifer be charged with a crime? Is she the cause of Tara's death? But for her speeding, losing control, hitting a tree, she was the actual cause, right? Is she the legal cause? Would a reasonable person foresee this resulted harm? Yes. So Jennifer, yes, can be charged. What about Bob? Isn't that a movie? What about Bob? Is Bob the actual cause? But for Bob speeding up laughing and then Jennifer speeding up more, can we make that argument for Bob being the actual cause? Is it reasonably foreseeable that both of these folks might be responsible? Yeah, this is actually, both of these folks can be charged. You can, both are the actual cause, because had Bob not sped up and just let Jennifer speed by and wave, it probably wouldn't have happened. And a reasonable person could foresee that happening. So work through that analysis. Do I have another one? Yeah, I do. Our intervening superseding cause. So I gave you that example. My slides seem to be a little out of order. So Hal is tired of living. He jumped off the top of a 15-story office building. Just as Hal was passing by the 12th floor, Julia, angry that her boyfriend Chet was leaving her, fired a pistol at him, intending to kill Chet. Chet moved, and the bullet missed him. Unfortunately, it went through the window of the 12th floor, killing Hal instantly in mid-flight. The prosecutor files murder charges against Julia. Is she guilty? Well, we have that issue of intent. Her intent was to shoot Chet, but missed. So what happens? Well, let's step back. Do we have an act? Yes, she fires the pistol. Do we have intent? Yes, because the intent to shoot at Chet transfers to Hal. Is she the cause of Hal? But for her shooting that bullet, Hal wouldn't have been shot. You might be saying, well, Hal was going to die momentarily anyway because he jumped off the building. Guess what? Doesn't matter. Julia's the cause. It was the bullet that killed Hal, and it is reasonably foreseeable that if you shoot a pistol, you could potentially shoot somebody, right? This is a weird situation, a weird fact pattern, but she shot the gun. She intended to shoot at Chet. The intent transferred when it hit Hal, despite the fact she didn't intend to shoot Hal, and despite the fact that Hal was going to die very shortly, does not take this out of the fact that she can be charged with murder. What if Cindy pushed Hal off the building, intending to kill him after he told her their relationship was over? And then all of the same other facts happen. Julia meant to shoot at Chet and missed and went out. Who killed Hal? Was it Cindy or was it Julia? Could Cindy be charged with murder? Or was Julia's action an intervening, superseding cause? When something interrupts the chain of events that the defendant started, it cuts off the defendant's liability because the intervening, superseding cause, is much closer. So Cindy would actually get off, and then the same result would happen. Julia would be would be able to be charged with murder. So that's how causation works. Remember that intervening superseding cause. And I know I have a little thing down there. It says video. I'm going to save that. Yes, it's got a bad ending. I'm going to save that for a different lecture. I think we had a lot of material here in this crime elements section.